Good afternoon, friends. This is Ash, WAT News, and I wanted to do a side dig today since I have a little bit of a news break. It doesn't seem like any too much major news broke today. And this is the flag of Washington, D.C. And as you see, it has 3 stars above these two, I guess, just straight lines. And I started to dive into this a little bit, and what's interesting about it is there seems like this is where we went off the rails. The two U.S. constitutions. This is from National Liberty Alliance, and it's just something about the two constitutions in the United States. The first was suspended in favor of a Vatican Corporation in 1871, and a little bit later I'm going to read the actual act. It's about 10 pages long, unfortunately. It's way longer than I thought. I thought it was just this minor deal, but it's not. So I'll try to save my voice and not read too many of these other things. But I just wanted to read a little bit of this. Pope meeting with the Board of Directors of the Vatican Bank. Since 1871, the United States President and the United States Congress has been playing politics under a different set of rules and policies. The American people do not know that there are two constitutions in the United States. The first penned by the leaders of the newly independent states of the United States in 1776. On July 4th, 1776, the people claimed their independence from Britain and democracy was born, and for 95 years, the United States people were free and independent. That freedom ended in 1871 when the original Constitution for the United States for America was changed to the Constitution of the United States of America, all capitals. The Congress realized that the country was in dire financial straits, so they made a financial deal with the devil, international bankers, in those days the Rothschilds of London, thereby incurring a debt to said bankers. The conniving international bankers were not about to lend the floundering nation any money without some serious stipulations, so they devised a way of taking back control of the United States, and thus the Act of 1871 was passed, with no constitutional authority to do so. Congress created a separate form of government for the District of Columbia. With the passage of the Act of 1871, a city-state, a state within a state called the District of Columbia, located on 10 square miles of land in the heart of Washington, was formed with its own flag and its own independent constitution, the United States secret second constitution. And I just showed you the flag right here. It's got the 3 stars. The flag of Washington's District of Columbia has 3 red stars, each symbolizing a city-state within the 3-city empire. The 3-city empire consists of Washington, D.C., London, and Vatican City. London is the corporate center of the 3 city-states and controls the world economically. Washington's District of Columbia city-state is in charge of the military, and the Vatican controls it all under the guise of spiritual guidance. Although geographically separate, the city-states of London, the Vatican, and the District of Columbia are one interlocking empire called Empire of the City. The Constitution for the District of Columbia operates under tyrannical Vatican law known as Lex Fori, local law. When Congress passed the Act of 1871, it created a separate corporation known as the United States and corporate government for the District of Columbia. This treasonous act has unlawfully allowed the District of Columbia to operate as a corporation outside the original Constitution of the United States and in total disregard of the best interests of the American citizens. So I thought that was an interesting little bit about it. And then this was talking about that this act was actually repealed, and then it was passed in 1871, repealed in 1874, then by piecemeal finally revised and passed in 1877, implemented in 1878. And it had precious little to do with us, as it was actually a restructuring of one of the foreign federal subcontractors to better avoid culpability for and to profit from crimes that the same guilty parties had already committed against us. So it goes on about after the war we were broke and they needed money and stuff, right? Um, After the Civil War, the victorious Union Army that fought for the Northern Confederation reorganized what was left of the federal territorial government to settle the bankruptcy Lincoln started in 1863, which he declared the day after he issued the first ever executive order, General Order 100. Among other things, prior to the Act of 1871, a Scottish commercial corporation, merely calling itself, quote, the United States of America Incorporated, foisted off its corporate articles of incorporation as the Constitution in 1868. So they formed a substitute entity, a foreign commercial corporation, named it after us, and started doing business in our names, impersonating us and illegally accessing our assets and credit starting in 1868. And in 1871 they began the same process of impersonation for the District of Columbia by creating the District of Columbia Municipal Corporation. That's not how it looks in here, but this is the actual, I found the actual bill, or the act, or whatever you want to call it, an act to provide a government for the District of Columbia. And this was February the 21st, 1871. I'll read as much of it as I can get through. It's an extremely lengthy document with a lot of words. So what we can do is I'll skip into different sections of it just to highlight, and then you could look it over at your leisure, but there's like 40, I think over 40 different sections to this particular act that they put through. So it's very layered, but there's some stuff in the beginning that I just wanted to highlight because it does appear to create this corporate body, right, which of Washington D.C., which is the problem since this time. And that may be part of the reason why there's a lot of chain link fencing around it, right? I don't know that, but it's interesting. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that all that part of the territory of the United States included within the limits of the District of Columbia be, and the same is hereby created into a government by the name of the District of Columbia, by which name it is hereby constituted a body corporate for municipal purposes, and may contract and be contracted with, sue and be sued, plead and be impleaded, have a seal, and exercise all other powers of a municipal corporation, not inconsistent with the Constitution and laws of the United States and the provisions of this act. So right there, it incorporatized it, right? It makes it into a corporate body, which it wasn't before. And now it gives it a separate government that and that is not, part of which is not voted for by the people. Some of it is, but not all of it, appears. So Section 2, and be it further enacted that the executive power and authority in and over said District of Columbia shall be vested in a governor, who shall be appointed by the president. Right? Not the people, the president. By and with the advice and consent of the Senate, so not the people, and who shall hold his office for 4 years, and until his successor shall be appointed and qualified. The governor shall be a citizen of and shall have resided within said district 12 months before his appointment, have the qualifications of an elector. He may grant pardons and respites for offenses against the laws of said district enacted by the legislative assembly thereof. He shall commission all officers who shall be elected or appointed. So, this guy's got a lot of power, but that wasn't like that before, right? Why are you changing it now? It further enacted that every bill which shall have passed the Council and House of Delegates shall, before it becomes a law, be presented to the Governor of the District of Columbia. If he approve, he shall sign it, but if not, he shall return it with his objections to the House, in which it shall have originated, who shall enter the objections at large on their journal and proceed to reconsider it. And all these other rules, right? So it goes on. Be it further enacted that there shall be appointed by the President by and with the advice and consent of the Senate a secretary of said district, who shall reside therein and possess the qualification of an elector. So that's another person that will be not elected by the people, right? Shall hold his office for 4 years, and until a successor shall be appointed and qualified, he shall record and preserve all laws and proceedings of the Legislative Assembly hereinafter constituted. So it's enacting different people. It's really long, so I won't read the whole thing because I just, it'll just kill me if I do that. But you guys can go through it, and you can look into different parts of it. It's an extremely interesting document with a lot of minutia. And be it further enacted that legislative power and authority in said district shall be vested in a legislative assembly as hereinafter provided. So it also provides for an assembly to be created of a council and House of Delegates. The council shall consist of 11 members. So they're changing the government in this particular place, right? All these new rules are coming into effect. How long that these people are going to go. And the president, by and with the advice and consent of the Senate, again, will be the person that puts these people in, right? It's not the people. The House of Delegates shall consist of 22 members possessing the same qualifications as prescribed for the members of the council. So it goes on to tell about that. I was looking for this one other section. Be it further enacted that the Legislative Assembly shall have power to divide that portion of the district not included in the corporate limits of Washington or Georgetown into townships, not exceeding 3, and create township officers and prescribe the duties thereof, but all township officers shall be elected by the people of the townships respectively. So they gave them that power. And be it further enacted that all male citizens of the United States above the age of 21 years who shall have been actual residents of said district for 3 months prior to the passage of this act, except such as are non-compos mentis and persons convicted of infamous crimes, shall be entitled to vote at said election in the election district or precinct in which he shall then reside, and shall have so resided for 30 days immediately preceding said election, and shall be eligible to any office within the said district. And for all subsequent elections 12 months prior, residence shall be required. And be it further enacted that no person who has been or hereafter shall be convicted of bribery, perjury, or other infamous crime, nor any person who has been or may be a collector or holder of public monies, who shall not have accounted for and paid over upon final judgment duly recovered according to law all such monies due from him, shall be eligible to the Legislative Assembly. Be it further enacted that members of the Legislative Assembly, before they enter upon their official duties, shall take and subscribe the following oath. I do solemnly swear or affirm that I will support the Constitution of the United States and will faithfully discharge the duties of the office. So nothing about to defend it against enemies, foreign and domestic. Somebody was saying that Biden didn't actually say that in the inauguration. I'll have to go check that. So it goes on. You can see we're on section 10 now. And be it further enacted that a majority of the Legislative Assembly appointed or elected to each house shall continue a quorum. The House of Delegates shall be and the judge of the election returns. So it's amazing how long this is and goes on for. And that it wasn't, it's amazing it was allowed to go through, because it enacts, it in a sense makes Washington, D.C. a corporate body that can entreat with others, right? Outside of the purview of the United States government, which it seems like, which it's part of and under the power of, right? So that's interesting. So some of this is just minutia. Some like how the bill should be read. Be it further enacted that no money shall be drawn from the treasury of the district except in pursuance of an appropriation made by law. And be it further enacted that each legislative assembly shall provide for all the appropriations necessary for the ordinary and contingent expenses. So how do you fund this thing? Be it further enacted that the Legislative Assembly shall never grant or authorize extra compensation, fee, or allowance to any public officer, agent, servant, or contractor after service has been rendered or a contract made, nor authorize the payment of any claim or part thereof hereafter created against the district under any contract or agreement made without express authority of law, and all such unauthorized agreements or contracts shall be null and void. The district shall never pay, assume, or become responsible for debts or liabilities of or in any manner given. So a lot of different stuff about payments. That the Legislative Assembly shall not pass special laws in any of the following cases, that is to say, for granting divorces, regulating the practice in courts of justice, regulating the jurisdiction or duties of justices of the peace, all these different rules. And be it further enacted that the legislative power of the district shall extend to all rightful subjects of legislation within said district. I think it was towards the end that there was a couple of interesting points, and there's a lot of stuff in here. And be it further enacted that the property of that portion of the district not included in the corporations of Washington or Georgetown shall not be taxed for the purposes either of improving the streets, alleys, public squares, or other public property of the said cities, or either of them, nor for any other expenditure of a local nature for the exclusive benefit of said cities, or either of them, nor the payment of any debt. So all this stuff, certain property not to be taxed for certain purposes. So it changes how the property is taxed. And be it further enacted that the property within the corporate limits of Georgetown shall not be taxed for the payment of any debt heretofore or hereafter, to be contracted by the Corporation of Washington. And I think that these places were corporatized in some way before this incorporation. So if Georgetown and some other part of it was incorporated before that, and I'll get to that in a second. It's about the schools. Be it further enacted that the said legislative assembly shall have power to provide for the appointment of as many justices of the peace and notaries public for said district as may be deemed necessary, to define their jurisdiction and prescribe their duties. But justices of the peace shall not have jurisdiction of any controversy in which the title of land may be in dispute. So you see, land is the big deal. Or in which the debtor's sum claims shall exceed $100. So basically these people don't have a lot of power. And be it further enacted that the judicial courts of said district shall remain as now organized until abolished or changed by an act of Congress. And be it further enacted that there shall be appointed by the President of the United States, by and with the advice and consent of the Senate, a Board of Health for said district to consist of 5 persons, whose duty it shall be to declare what shall be deemed nuisances injurious to health, and to provide for the removal thereof. So it gives a lot of power to the president, right? Much more powers to the president, because he gets to pick all the different people in this particular area now that will be not just sheriffs or justices of the peace, but a lot of different people, right? Different jobs. And be it further enacted that the offices and duties of Register of Wills, Recorder of Deeds, U.S. Attorney, and United States Marshal for said district shall remain as under existing laws, till modified. And be it further enacted that the said legislative assembly shall have power to create by general law, modify, repeal, or amend within the said district corporations aggregate for religious, charitable, educational, industrial, or commercial purposes, and to define their powers and liabilities, provided that the powers of corporations so created shall be limited to the District of Columbia. So now this gives them power over the corporations that also exist within the District of Columbia now, right? And that's a big deal, because it gives you a lot more power. Now you can try to get bribes from people and say, hey, I'll go easier on you maybe if you give me some cash, right? It leaves a lot of openings for graft. It puts more power into the hands of the president in that particular party at that particular time that's in power. And be it further enacted that the Legislative Assembly shall define by law who shall be entitled to relief as paupers in said district, and shall provide by law for the support and maintenance of such paupers, and for that purpose shall raise the money necessary by taxation. So they can also levy more taxes on you. And be it further enacted that the Legislative Assembly shall have power to provide by law for the election or appointment of such ministerial officers as may be deemed necessary to carry into effect the laws. So they can put ministers in effect as well. And be it further enacted that the governor, secretary, and other officers to be appointed pursuant to this act shall, before they act as such, respectively take and subscribe an oath or affirmation before a judge of the Supreme Court of the District of Columbia or some justice of the peace in the limits of said district, duly authorized to administer oaths or affirmations by the laws now enforced therein, or before the Chief Justice or some associate justice of the Supreme Court of the United States. That's interesting. And be it further enacted that the governor shall receive an annual salary of $3,000, and the secretary shall receive an annual salary of $2,000, and that the said salary shall be paid quarterly, yearly from the dates so they get paid. The members of the Legislative Assembly shall be entitled to receive $4 each per day during their actual attendance at the session thereof, and an additional allowance of $4 per day shall be paid to the presiding officer of each house for each day he shall so preside. So they get $4, which back then was a nice piece of money. Could buy a lot with $4 back in 1871, man. A whole lot. And the chief clerk shall receive $4 per day, and the said other officers $3 per day, provided that there shall be but one session of the Legislative Assembly annually, unless on an extraordinary occasion the governor shall think proper to call the Legislative Assembly together. So that's how they'll be paid. I think I'm getting to the more interesting stuff. Sorry guys, I know it's long, but it's worth it to read, because it's you can see how much went into putting into this act, right? How many different laws and things, and how they're clawing more power out of this particular area now, that will reside in the hands of less people and in an incorporated, Washington, D.C. And be it further enacted that the Legislative Assembly of the District of Columbia shall hold its first session at such time and place in said district as the governor thereof shall appoint. And be it further enacted that a delegate to the House of Representatives of the U.S. to serve for the term of 2 years, who shall be a citizen of the U.S. and of the District of Columbia, and shall have the qualifications of a voter, may be elected by the voters qualified to elect members of the Legislative Assembly, who shall be entitled to the same rights and privileges as are exercised and enjoyed by the delegates from the several territories of the United States to the House of Representatives, and shall also be a member of the Committee for the District of Columbia, but the delegate first elected shall hold his seat only during the term of the Congress to which he shall be elected. First election shall be held at the time and places excuse me, and be conducted in such manner as the elections for members of the House of Representatives are conducted. So they really write this stuff out. It's hard to keep up with, And be it further enacted that all officers to be appointed by the President of the United States by and with the advice and consent of the Senate for the District of Columbia, who, by virtue of the provisions of any law now existing, or which may be enacted by Congress, are required to give security for monies that may be entrusted to them for disbursement, shall give such security at such time and in such manner as... So they had to actually give money up to get this particular certain positions, because they were entrusted with monies. That's interesting. And be it further enacted that there shall be a valuation taken in the District of Columbia of all real estate belonging to the United States in said district, except the public buildings and the grounds which have been dedicated to the public use as parks and squares, at least once in 5 years, and return thereof shall be made by the governor to the President of the Senate and Speaker of the House of Representatives on the first day of the session of Congress held after such valuation shall be taken, and the aggregate of the valuation of private property in said district, whenever made by the authority of the Legislative Assembly, shall be reported to Congress by the governor, provided that all valuations of property belonging to the United States shall be made by such persons as the Secretary of the Interior shall appoint, and under such regulations. And this just says there'll be a 4-person board to be appointed by the President, by and with the advice and consent of the Senate, one of whom shall be a civil engineer, and the other citizens and residents of the district having qualifications. Let me go down towards the end. We're almost done. And be it further enacted that the officers herein provided for, who shall be appointed by the President by and with the advice and consent of the Senate, shall be paid by the United States. Be it further enacted that if any election hereafter held in the District of Columbia, any person shall knowingly personate and vote or attempt to vote in the name of any other person, whether living, dead, or fictitious, or vote more than once at the same election for any candidate for the same office, or vote at a place where he may not be entitled to vote, or vote without having a lawful right to vote, or do any unlawful act to secure a right or opportunity to vote for himself or any other person, or by force, threats, menace, or intimidation, bribery, reward, or other, or offer or promise thereof, or otherwise unlawfully prevent any qualified voter of the District of Columbia from freely exercising the right of suffrage, or by any such means induce any voter to refuse to exercise such right, or compel or induce by any such means or otherwise any officer of any election in said district to receive a vote from a person not legally qualified or entitled to vote, or interfere in any manner with any officer of said elections in the discharge of his duties. And it goes on and on to say that you will get 3 years in prison, or shall be punished by a fine not exceeding $500, or by imprisonment for a term not exceeding 3 years, or both. And be it further enacted that the charters of the cities of Washington and Georgetown shall be repealed on and after the first day of June A.D. 1871, and all offices of said corporations abolished at that date. The levy court of the District of Columbia and all offices connected therewith shall be abolished on and after said first day of June A.D. 1871, but all laws and ordinances of said cities respectively and of said levy court not inconsistent with this act shall remain in full force until modified or replaced by Congress. That portion of said district included within the present limits of the city of Washington shall continue to be known as the city of Washington, and that portion of said district included within the limits of the city of Georgetown shall continue to be known as the city of Georgetown, and the legislative assembly shall have power to levy a special tax upon property except the property of the government of the United States within the city of Washington for the payment of the debts of said city, and upon property except the property of the government of the United States within the limits of the city of Georgetown for payment of the debts of said city. Provided that the charters of said cities severally and the powers of said levy court shall be continued for the following purposes, to wit, for the collection of all sums of money due to said cities respectively. Sorry, I lost my place. Shall be continued for the following purposes, to wit, for the collection of all sums of money due to said cities respectively, or said levy court, for the enforcement of all contracts made by said cities respectively, or by said levy court, and all taxes heretofore assessed remaining unpaid, for the collection of all just claims against said cities. And it just keeps going on and on and on. I think it's almost, this is at the end. And be it further enacted that there shall be no election holden for mayor or members of the common council of the city of Georgetown prior to the first day of June. And then it sort of ends, right? and it tells you all the salaries. But the interesting thing about this whole thing, and you could read through it at your leisure, I'll put it in the links, is that it corporatizes, it makes Washington, D.C. into a corporation. And that shouldn't have happened, right? Because it shouldn't be. You're under you are within the United States. You can't create a separate corporatized entity that now is within, and now the president has certain powers over that entity to elect certain people. The District of Columbia Act, 1871. I read the District of Columbia Organic Act of 1871, and it seems like it only sets up a local government. So I'm curious, how does that act show that they instead formed a private corporation? Our response, if you were to take the act out of its historical context and from the present looking to the past, imagine who the parties involved are, we might agree. However, it's highly unlikely that anyone can ever understand any historical effect by looking from the present to the past. Therefore, we find the only way to truly understand that or any act is to follow our standard for review. Following the standard for review, we can resolve the inquiry not by delving into the act in its entirety, but by simply discovering who the involved parties, along with comparing a small portion of the historical background to the effects of the act. Because in 1871 Corp, U.S. did not exist, the date of the act shows it was made by the original jurisdiction Congress set by the Constitution for the United States of America. The act itself describes its venue as all that part of the territory of the U.S. United States includes within the limits of the District of Columbia. The District of Columbia was originally provided for in the Constitution for the United States of America, 9/17/1787, at Article 1, Section 8, specifically in the last two clauses. Then, on July 16, 1790, in accord with the provisions of those clauses, the territory was formed in the original District of Columbia Act, wherein the 10-mile square territory was permanently created and made the permanent location of the country's government. That is to say, the territory includes the actual government. Under the Act, Congress also made the President the civic leader of the local government in all matters in said territory. Then on February 27, 1801, under the 2nd District of Columbia Act, 2 counties were formed, incorporated, and their respective officers and district judges were appointed. Further, the established town governments of Alexandria, Georgetown, and Washington were recognized as constituted and placed under the laws of the district, its judges, etc. The U.S. Supreme Court has repeatedly called this act the District of Columbia Organization Act, or the Charter Act of the District of Columbia, and recognized it as the incorporation of the municipality known as the District of Columbia. Then on March 3rd, 1801, a supplementary act to that last act added the authority that the marshals appointed by the respective district court judges collectively form a county commission with the authority to appoint all officers as may be needed in similarity to the respective state officials in the states whence the counties Washington and Alexandria came, those being Maryland and Virginia respectively. According to the U.S. Supreme Court, those charter acts, first acts, were the official incorporation of the formal government of the District of Columbia as chartered by Congress in accord with the Constitution's provision. Again, the Supreme Court called that body of government a corporation, with the right to sue and be sued. Since 1801, the District of Columbia has been consistently recognized as a municipal corporation, with its own government, including but not limited to the right to sue and or be sued as such. That sets the basics for the first rule of our standard for review: know the parties. Thus, what we have here presented is sufficient to show the basics of who the parties are as they related to resolving the answer to the question above. We admonish everyone to prove the facts for themselves by their own supportive research. The second rule from our standard for review is then you must understand the environmental nature of the relationship. With that in mind, let's consider the events of the time. The Civil War had recently ended and the country was still under Lincoln's Conscription Act martial law. Congress had at least 3 problems they could see no way to directly cure by following the laws of the land. They were out of funds. They had promised 40 acres of land to each slave that left the South to fight for the North, and they had to reintegrate the South back into the Union, which they could not do without controlling the appointment of the Southern states' congressional members. There were other problems, but these three stand out from the rest. Of course, for the purposes of this review, that is enough information about the environment of the relevant relationships. However, the more you study the historical events of this time, the more obvious the relationships will become, and the more proof you will amass to prove the facts of what actually happened. In the interest of time and space in this response, we will move on. Last step of the review's discovery process requires a review of the actual terms of the relationship. Thus, we review the first paragraph of the District of Columbia Organic Act of 1871, where Congress wrote that all that part of the territory of the U.S. included within the limits of the District of Columbia be, and the same is hereby created into a government by the name of the District of Columbia, by which name it is hereby constituted a body corporate for municipal purposes and exercise all other powers of a municipal corporation. Knowing the government of the District of Columbia was already created into a government and was so formed into a municipal incorporation in 1801 under the District of Columbia's acts, we wonder, even with Congress's constitutional authority to pass any law within the 10-mile squares of the district, how do you create or incorporate for the first time, which is what is meant by organic, a municipal government that has already been in existence as a municipal corporation for over 70 years? The obvious answer is it's impossible. There's no lawful way to pass a new organic act when the Charter Act is already in place, because the two words organic and charter have the same meaning. The first act, even Congress cannot change history, though historians can make it appear to change by rewriting it for those unwilling to study the past from its actual records. The records speak for themselves only if we study them. Respectfully, when you consider the historical facts, the only meaning left for the terms given in the opening paragraph of the District of Columbia Organic Act of 1871 and that which follows is, the municipal corporation that was created is a private corporation owned by the actual government. Accordingly, the only government created in that act was the government formed by the mere governing authority any private corporation has within the confines of managing its own corporate construct. Thus, we call it Corp US. We also note Congress reserved the right granted them in the Constitution to complete dictatorial authority over their Corp US construct without regard for its internal operations or officers. Thus, as a matter of law, Congress can use Corp US within the 10-mile square of the District of Columbia as they see fit. However, outside of that specifically defined venue, the only way they can exercise their respective authority is by agreement with other agreeable parties. To that end, they form their social security system. So, super interesting, right? Did they actually, was this actual thing done in 1871 legal? It doesn't appear to be to me, but, we'll have to see how everything pans out in the end, and if some of these things that were done in the past were actually not done in a legal fashion, and once overturned will change things up in a big way, right? Because they basically corporatized the District of Columbia, and it already had been a municipal corporation, right? It had already been in existence as a municipal corporation for 70 years. You can't just change that. It's impossible to do. So how did they do it, right? How did they change how Washington, D.C. was? How did it get this new flag, right? So anyway, guys, I appreciate you listening. There was another couple of things I have to look at, but it's just one more, and I'll include it in the links. It was from American National Militia, so I'm not sure how accurate everything on there was, but it was some interesting stuff. So I'll include it in the links. This is the end of the dig into the Act of 1871, the Organic Act of 1871. So thanks for listening, friends. This is Ash, WAT News, signing off for now.